Hello friends. In this video we are going to study Article 39 of UCP 600 Assignment of Proceeds. Let us first read the entire article. The fact that a credit is not stated to be transferable, shall not affect the right of the beneficiary to assign any proceeds to which it may be or may become entitled under the credit, in accordance with the provisions of applicable law. This article relates only to the assignment of proceeds and not to the assignment of the right to perform under the credit. Let us one by one see the highlighted part of the text and see what it means. Even if the credit is not stated to be transferable, UCP 600 Article 39 recognizes the beneficiary's right to assign any proceeds to a third party. It is totally based on provision of national or local law governed. The beneficiary may assign its right to receive some, or all, of the proceeds to a third party. This arrangement is normally done to give security to the pre-financing, to issue back-to-back LC. To summarize Article 39, the extent and legal effect of assignment of proceeds under a letter of credit is determined by local laws. It is possible, in some cases, for the beneficiary to ask the nominated bank or issuing bank to reserve part of the proceeds to be paid to its own supplier. This request is worded in the form of an irrevocable instruction. The bank then tells the supplier in the form of bank letter, that it has received irrevocable instructions to make the relevant payment to the supplier out of the documentary credit proceeds. The bank will not undertake any payment or guarantee obligation towards such supplier, and this should be made clear in the bank's letter given to supplier. The bank merely acts as an agent for payment of the money received on behalf of the beneficiary or the seller. The bank should exercise care in wording the bank letter to avoid any risk that it might be called on to pay the supplier, if it does not have free use of the proceeds received from performance of the documentary credit. This situation would arise if, for instance, the proceeds were seized by a creditor of the beneficiary. For example, let's take a common scenario that creditor was supposed to give $1,000 to beneficiary through bank. Beneficiary has given irrevocable instructions to bank to pay $500 to its supplier. $50 being the fixed bank charges irrespective of the transaction amount. Remaining proceeds of $450 has to be credited to beneficiary. Now considering the above instructions, let us say that the creditor has seized the proceeds. In that case, bank is not responsible to make any payment to supplier. Also consider another scenario, that due to some reason, let's say for example due to quality issue, the creditor has remitted only $500. Since the bank does not have any free proceeds to pay to supplier, it does not have any obligation to pay to it. Hence, after deducting bank charges, it will pay remaining amount to the beneficiary. Let's take one more example. The creditor has remitted only $550. Now $50 being bank charges, the free proceeds is $500. Bank will pay $500 to the supplier and will not pay any amount to the beneficiary. This is the end of the topic. Please like, share, comment. For more videos please subscribe my channel.